All right. Good afternoon, ladies and gentlemen and committee. It is Tuesday, February 20th, 2024. House Criminal Session Full is now in session. Madam Clerk, please take the roll.
Representatives Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson of Knox, Lamberth, Moody, Russell, Towns, Vice Chair Gillespie, Chairman Hulsey. Mr. Chairman, you have a quorum.
Thank you very much. Members, do you have any personal orders for anybody today? Seeing none, we're going to move right along. For the words of inspiration today, we have Dr. Tyler.
Thank you, Chairman. Good afternoon, everybody. Today's words of wisdom come to you from a two-time WWE champion, four-time WCW World Champion, and a 14-month reigning Intercontinental Champion, Macho Man Randy Savage. There's one guarantee in life. There are no guarantees. Yeah. And understand this. Nobody likes a quitter. Have a great afternoon.
Thank you. Thank you. All right, that brings us up to item number 1 on the calendar. It's HJR 0859 by Representative Capley. Representative Capley, you're recognized. You have a second. You have a motion and a second, too, by the way.
Thank you, Mr. Chairman. Members, HJR 859 does not change the law. Rather, it seeks to give the people of Tennessee the opportunity to vote, to have a voice through a constitutional amendment on how we should address violent crime in the future. It is the most democratic thing that we can do. Currently, in the state of Tennessee, a judge has discretion in denying bond only in capital murder cases. At present, the Constitution says all prisoners shall be bailable by sufficient sureties unless for capital offenses. That's in Article 1, Section 15. If approved by a vote of the people, the amendment would say all prisoners shall be bailable by sufficient sureties unless for the following: when the proof is evident or the presumption great, A, capital offense, an act of terrorism, second-degree murder, aggravated rape of a child, aggravated rape, grave torture, and any other offense for which, as of November 3rd, 2026, a defendant, if convicted, could not be released prior to the expiration of at least 85% of the entire sentence imposed. This amendment, if approved by the people of Tennessee, would expand a judge's discretion on granting bail to these other violent crimes in addition to capital murder. And Mr. Chairman, I stand ready for questions.
Okay, thank you. Today we have somebody who would like to speak on this issue. So without objection, we'll go out of... Is Mr. Jeffrey Clayton here? He is. So we'll go out of session. Welcome, Mr. Clayton. Thank you for being here. Will you please make sure the red light's on your mic there and introduce yourself for the record, please? And you have 3 minutes for opening remarks, and then we will open it up to the committee for questions.
Are we on here? Okay. Thank you, Mr. Chairman. My name is Jeff Clayton. I'm the Executive Director of the American Bail Coalition. I'm also an attorney and a national expert on bail and bail reform. The history of this constitutional amendment lasts for 809 years. And so that means really two things. As an advocate, it means job security for me because it's going to go on for a while, but also means I got to cover a lot of ground here in 3 minutes. The language in the Tennessee Constitution is called the Ancient Rule. Dates to 1215, the year 1215. That language was written at the Magna Carta at Runnymede and has continued unbridled in the Tennessee Constitution. In the year 1275, the English Parliament began tinkering with the ancient rule of bail by sufficient sureties except in capital cases by adding crimes. And over a period of 400 years had added so many crimes that the right to bail was virtually meaningless. And so when the colonists came here to this country, they said, we want the ancient rule back. And the ancient rule was brought back in the Massachusetts Body of Liberties in 1641 and the Pennsylvania Constitution, upon which the Tennessee Constitution was copied. And so there's good reason for having only the exception only be for capital cases. And really, it's to protect the presumption of innocence. What William Blackstone calls the dubious interval between arrest and conviction, when even in the Middle Ages, we were supposed to treat the unconvicted with, quote, the utmost humanity. But of course, being in jail in the Middle Ages was not fun. In fact, Blackstone said jailers were a merciless race of men, being conversant in such scenes of misery, steeled against any tender sensation. But the point is, being in jail is bad, and the presumption of innocence is good, and we think keeping it in the ancient rule is a good thing. Two other quick points is we think this crime should be specifically listed and not left to future enactments of legislators. In other words, tell the people what the crimes are. If you commit this crime, you get no bail. And we see other states putting the specific crimes rather than delegating future power to the legislature to get into this exercise of the Statute of Westminster and repeat the 400 years of history all over again. The third point is this effective date is fixed to the date of the election, which means the crimes can be changed by the legislature at any time. For example, if we say that 80% is good enough and we're going to take all the 85% crimes and make them 80, we have gutted this constitutional amendment. And that can happen up until 11:59 on the day of the election. And so the voters technically will not know. I think the counter to that is, the sentencing law is probably not going to change. But we think regardless of where you land on this, give the voters and the people certainty. And remember, you can't change it after this round. So we need to get it right the first time, unlike other bills. So tell the people what the categories are, and I think we'll have a good debate about it. So thank you very much for your time, and I wish you a good day.
Thank you, sir. Questions, Leader Lambert?
Thank you. And sir, I'm sorry, what organization did you say you're with again?
American Bail Coalition?
Okay, and who makes up that coalition?
Yeah, we're a trade association of insurance corporations that underwrite bail throughout the United States.
Okay, and you write bails in states that have more crimes on the books that prohibit a bail than just capital offenses, correct?
Well, my member companies underwrite bail in 45 states. So the answer is yes, of course.
And is your real concern in Tennessee that your member organizations are just going to lose money if we pass this?
Not really. We stand for principle for the ancient rule, and I have since I've taken this job 10 years ago. I'm writing a law review article on how I don't think state legislatures should have the power to reverse the ancient rule, and that the U.S. Supreme Court should overrule U.S. versus Salerno. So I'm really not here in much of a financial interest. We stand for the ancient rule. We think it's best practices in terms of bail.
So there's not an email chain amongst a couple of your members that indicates they're worried they're going to lose money over this. You're confident in that?
Well, if it's my member corporations, I'd be ashamed, and two, I'd like to see it because
Okay.
my insurance members are proud corporate citizens of Tennessee. We would never oppose or support a bill based on that.
That's what I wanted to hear publicly. All right. And just curiosity, in these other states that have this type of option out there for citizens to decide on this and don't allow bond in some of these heinous incidents, do you think it improves or diminishes public safety?
I'm
just
sorry.
asking for your opinion on it.
And you said when citizens decide, I assume you mean judges can decide in this.
Well, citizens on this case to decide whether or not on
Got
the
it.
ballot. So I'm just kind of putting that in, but we'll go with if it were to pass, the end result. Sorry, better question.
Absolutely. There's been no academic research that supports the use of preventative detention as an effective crime control policy. In fact, there's a litany of articles that suggest that it doesn't have an impact on crime control policies. And so I think the federal government and the research by the University of Chicago's center, in fact, we had them invited to an ALEC meeting to talk about the impact of the federal system. The evidence that it effectively fights crime just isn't there. And the answer is go get a conviction, unfortunately.
Good.
Just one last question. And again, I really appreciate your testimony today. You represent a whole lot of folks. And so I just wanted to make sure kind of where we were. But there's a really nice lady by the name of Mamie Turner. Her son was shot and killed right here in Nashville by a teenager. And you may or may not have seen in the news just yesterday, he was picked up again for trying to kill somebody else. I understand there may not be any academic research out there on it, but surely you would concede that there are some individuals who commit repeated violent crimes and they need to be held for the safety of their community. How do you make that mesh with the presentation you just gave?
Well, I would just quote from U.S. versus Salerno, which is the shortcuts we take. And that is what preventative detention is a shortcut to a conviction. And it also delays justice because we have no incentive to get a conviction speedily. And we've seen in the federal system, the time to disposition go from 60 days to a year solely as a result of the shortcut of getting them in jail in preventative detention, knowing they're not going anywhere and not affecting the process. So I would tell any person that it's all about getting a conviction. Bail is just a step to getting it done correctly, which is to get a conviction. And that's what we need to focus on. If we focus on putting them in jail for purposes of bail, we're missing the point, which is to get a conviction to deter crime, which is certainty of getting caught, swiftness of punishment. And those are the two things we need to focus on right now in light of a crime wave.
Well, sir, thank you for your back and forth today. I really appreciate it. It sounds to me like you come from just a genuine belief on this issue. We may or may not agree with it, but I appreciate both the history lesson on it and your fervent advocacy for this issue. Thank you, sir.
Certainly, and after 809 years, we can expect there's a lot of opinions on all sides of this issue.
Any other questions for Mr. Clayton? Okay, seeing none, sir, thank you so much for your time. I
Thank you.
appreciate the information. We're back in session. Representative Capley, anything else?
Thank you, Mr. Chairman. I stand ready for questions.
Representative Johnson.
Thank you, Mr. Chairman. Mine is the same again, and it's actually was addressed by the gentleman who just spoke. It's still that we don't have a list of what those things are going to be, that it could change up until the point that citizens vote. And that's a real, does that bother you at all that that can change? We know that this legislature is quite apt to change it to a lot more capital crimes. So is that a concern for you at all?
Go ahead.
Thank you, Mr. Chairman. My simple answer to that would be that we wouldn't want to leave anything out, and that I trust the citizens of Tennessee when they see this piece of legislation and they see the thing, they see those things before them, that they will make an educated decision going forward.
Well, thank you for that answer. I don't always trust that the information and the way these things are written are very difficult a lot of times for folks to understand. Even a friend of mine who read one of them the last time, brilliant guy, but he read it wrong. And so they're kind of confusing when in the language that they come in. So getting everybody the message is tough. But for me, not knowing in advance right now as we vote on this, what all of these are going to be, it's not something that I could support. But thank you.
Okay, just for a point of clarification, I want to go out of session and let legal explain something for a second. Legal.
Michelle Fogarty, Legal Services. So the legislature would not be able to change any offense impacted by this amendment after 11:59 on November 2nd of 2026. So if there were any offenses added, required to be served at 85 or 100%, they would have to be added before 11:59 p.m. on November 2nd, I'm sorry, November 2nd, the day before. So they would not be, the legislature would not be able to change it as of November 3rd. Correct.
Okay, another question for legal on that? Representative Hardaway.
Thank you. I want to make sure the day before the people vote, we can change it up until the day before the actual
The
vote.
legislature would have to be in session and they would have to pass a bill. It would have to pass both the House and the Senate. The legislature would have to be in session for that to happen.
And with the language, with that shorter time period, would the language be changed on the ballot, the description?
No, sir, the constitutional amendment as written says any other offense for which, as of November 3rd, 2026, a defendant, if convicted, could not be released prior to the expiration of at least 85% of the entire sentence imposed.
All right. And would that include any nonviolent offenses?
I can read you a list of the current offenses that are required to be served at 85 or 100%, if you would like.
No, ma'am, I think that's a rather extensive list. And are you able to determine whether there are nonviolent offenses in that list?
Most of them are first-degree murder, second-degree murder, active terrorism, aggravated rape, facilitation of rape of a child, aggravated statutory rape, sexual battery, indecent exposure when the offense is a felony offense, continuous sexual abuse of a child, incest, child abuse, child neglect or endangerment, vehicular homicide. There's about 71 of them. It appears that most of them involve some sort of act of violence.
Are there drug crimes also included?
The manufacture, delivery, or sale of a controlled substance where the instant offense is classified as a Class A, B, or C felony and the person has 2 or more prior convictions for the manufacture, delivery, or sale of a controlled substance classified as an A, B, or C felony.
Okay. All right. Thank you, ma'am.
Any other questions for legal? Yes, sir.
Thank you, Mr. Chairman. So November the 2nd, we would have to be in session, the bill voted on, and then it would be on the ballot. Is that correct?
Questions
No.
for legal?
Michelle Fogarty, Legal Services. No, it would have to actually be a law, have become a law before 11:59 on November 2nd.
Okay, so if folks who have early voted, who took the opportunity to early vote, will they have an opportunity to know what they're voting for before then?
The language would be as it is written here. I can't speculate as to what the legislature may or may not do at that time period, but the language of the amendment would stay the same.
Representative Glenn?
Thank you.
Any other question for legal? Okay, thank you, legal. We're back in session. Any other questions for the sponsor of the bill? Leader?
Move previous question.
Question's been called for. We're going to vote on HJR 0859. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Moves on to calendar and rules.
Thank you, Mr. Chair and committee.
That brings us to item number 2, House Bill 2265 by Representative or Chairman Boyd. Chairman Boyd, you got a motion, and did I hear a second? You got several seconds, so go right ahead.
Thank you, Mr. Chairman and committees. Members, one of the greatest threats that we face in America, in Tennessee, and in any westernized nation is an attack to our critical infrastructure, or what we've seen recently is a cyber attack. And so this General Assembly, in fact, this committee helped last year as we took a attack on critical infrastructure from a Class E felony to a Class C felony. In the Commerce Committee a couple of years ago, we've started requiring all of our utilities in this state to develop and implement cybersecurity plans and update their respective regulatory authority, TPUC or the Comptroller's Office. And all this bill does is it takes that language that we did last year in this committee, criminalizing an attack on critical infrastructure, and it adds a cyber attack to the list of crimes. Mr. Chairman, I'll take any questions.
All right, any questions for the sponsor? All right, seeing none, we're voting on House Bill 2265. All those in favor say aye. Aye. All opposed, no. The ayes have it, sir. Goes on to calendar and rules.
Thank you, Chairman and committee.
That moves us to item number 3, which is House Bill 1909. You have a motion and a second. And Representative Bolso, you're recognized.
Thank you, Mr. Chairman. Good afternoon, members of the committee. This is a bill that would that provides that colleges and universities in Tennessee would be prohibited from requiring that adults on their campuses, especially students, not be permitted to carry non-lethal weapons such as pepper spray gun, mace, stun gun, other types of electronic controlled devices. It obviously would apply to all adults who are lawfully on a public college or university, but it would specifically allow students on these large college campuses that we have to carry non-lethal weapons for their personal defense. And with that, Mr. Chairman, I'm ready for questions.
Okay, thank you, sir. And I think we got an amendment to put on this bill. Is that correct?
We do, Mr. Chairman.
I'm showing 013495. Is a motion and a second. Do you agree with that number?
Yes, that is correct, Mr. Chairman.
Okay, we're going to vote to move this amendment onto the bill 013495. All those in favor say aye. All opposed, no. Amendments on the bill. Any questions for the sponsor? Yes, Representative Hardaway.
Thank you, Chairman. And good afternoon to the sponsor.
Good afternoon.
Was there any consideration, two things. One is that some of the quote non-lethal, and I don't think there's that some of these things aren't non-lethal. It kind of depends on who's on the receiving, the business end of it. Is there any consideration for that in language that the user of that weapon would have to consider the impact, whether it's on age or other infirmities? And the other is whether there's anything in the bill that gives consideration to young adults and juveniles who are on campus, and the fact that we have the research, which is really the impetus for other bills that are moving through on blended sentencing, that the prefrontal cortex is not fully developed, that governs your rational thinking, your impulsive behavior, et cetera. Was there any consideration in writing this language for those two items?
Thank you, Mr. Chairman. With respect to your first question, Representative Hardaway, the answer is no. There's nothing in here that addresses the characteristics of the person against whom one of the non-lethal weapons may be deployed. It simply specifies that the device be a non-lethal device, as that term is defined in the bill. The device, when used as designed, would not set forth any type of lethal force. And with regard to your second question, the bill does only apply to adults on campus as being permitted to use the non-lethal weapons. So this is not a bill that would contemplate that a juvenile, for example, would be on a college or university campus and using any type of the non-lethal weapons that are defined in the bill.
And I'm sure you know this, but just for the public's consumption, blended sentencing takes into account the research that it's not about juveniles as much as it is that gap between 18, 19 and up to 25, when you will have, or generally you'll have, a fully mature brain and able to make adult decisions. So I'm concerned about those that you refer to as young adults, or I refer to as young adults, having the state endorsement to use what you call non-lethal, I'll call them sometimes lethal weapons. And I'll leave it there. But the other question is about civil liability. How does your bill address civil liability if someone is injured or someone dies, even when that weapon is used as recommended?
Thank you, Mr. Chairman. The bill does not address civil liability, so whatever the law currently is with regard to the standard of care for the use of any type of a non-lethal weapon, that standard of care would apply with equal force to anyone acting pursuant to this bill, should it be passed.
All right. Thank you for your answers. I'm going to have to do a little bit more pondering on this, but today I'll have to vote no. All right, thank you.
Representative Towns.
Chairman, come back to me, Mr. Chairman. Move me one down.
Leader Lambert.
Move previous question.
Previous question been called. We are going to vote now on House Bill 1909. All those in favor say aye.
Aye.
All opposed, no. The ayes have it. It moves to Education Administration, sir.
Thank you, Mr. Chairman. Thank you.
Thank you. That brings us to item number 4, which is House Bill 2205 by Representative Barrett. All right, going to roll this. We're going to roll this a couple of spaces down the counter. That brings us to item number 5, HJR 0798 by Representative McCalman. You got a motion and a second. Representative, you recognized.
Thank you, Chairman, and thank you, members. I would request a roll call vote on this, please.
Solely noted.
Thank you, Chairman. Members, what this resolution does is urge the governor and the attorney general to work with neighboring states to create a network so that we can quantify and track human trafficking and hopefully use that data to put a stop to it. So with that, I stand ready for questions.
Any questions for the sponsor? Representative Johnson.
Yes, I guess I still have the same question as before. Since it involves interstate, are we the ones that are handling that, or is that handled by the federal government? What is our role in that?
Representative Johnson, this would be aside from the federal government. This would be a coalition of this neighboring states in the Southeast being able to track our portion of the country to say, this is the data we've got on human trafficking activity, be it from here, Kentucky, South Carolina, Alabama, Mississippi, any of the states that are in the area, to say, hey, this is going on through Texas into Arkansas into Tennessee, knowing where that is coming from, so we can work to put a stop towards it. But it's outside of the federal government.
Okay, so you say so that we can work. So you're talking about us working in conjunction. Are we also going to be working with the feds?
Go ahead.
I imagine we are working with the feds as it sits. I mean, this is something separate for us as the state of Tennessee to have that data that we may not be receiving from the feds at this point. So,
Reverend Johnson? That's it? Okay. Any other question for the sponsor? All right, clerk, please take the vote.
Representatives Carringer. Carringer votes aye. Representative Davis. Davis votes aye. Representative Doggett.
Aye.
Doggett votes aye. Representative Farmer. Farmer votes aye. Representative Fritz. Fritz votes aye. Representative Glenn. Representative Hardaway. Hardaway votes aye. Representative Howell. Howell votes aye. Representative Johnson. Johnson votes aye. Representative Lamberth. Lamberth votes aye. Representative Moody. Moody votes aye. Representative Russell. Russell votes aye. Representative Towns. Towns votes aye. Vice Chairman Gillespie. Gillespie votes aye. Chairman Holsey.
Aye.
Chairman Holsey votes aye. Mr. Chairman, you have 14 ayes.
14 ayes. That's a bad look, isn't it? All right, HJR passes and moves to calendar and rules.
thank you, Chairman of the Committee.
Congratulations, sir.
Mr. Chairman,
Yes, sir.
I'd like to switch my vote.
Please see the clerk. That brings us back to item number 4. There's a motion and a second. Let me get to 4. House Bill 2205 by Representative Barrett. Oh, Towns is going to take it. I'm sorry.
Mr. Chairman, I'm gonna run it if you don't mind.
You go right
Where I get
ahead.
in trouble, I'll talk to the leader. Mr. Chairman, members, I have a first and a second.
You do have a motion and a second.
Okay, thank you, sir. Yeah. As introduced, established that the district attorney general shall only prosecute cases in the municipal court where the municipality provides sufficient additional prosecutorial personnel for the district attorney general. Empowers the district attorney general with the sole and exclusive discretion in determining the necessity and sufficiency of the additional prosecutorial personnel. Specifies that the particular resources that the district attorney general has absolute discretion to use the performance of their duties and responsibility. And in essence, Mr. Chairman, that pretty much explains the bill.
Okay. Questions for the sponsor, Leader Lambert.
Move previous question.
Question has been called on the bill. There is an objection. Oh, are you objecting to the objection? All right, that has been withdrawn. We're voting on the House Bill 2205. All those in favor say aye.
Aye.
All opposed, nay. Ayes have it. Moves on to finance.
Mr. Chairman, thank you, members. You took it easy on Representative Barrett and me. You're welcome, sir.
Is that wrong on 6? That brings us to item number 6, House Bill 2188 by Leader Lambert. Motion and a second. Leader, you recognize.
Thank you, Mr. Chair, members of the committee. I know I explained this in sub, but just very, very straightforward, is that good time credit goes toward someone's release eligibility. It doesn't reduce their actual sentence. This is an issue that came up recently in an aggravated vehicular homicide case that I had prosecuted years ago. And when someone made parole, it was a 22-year sentence. This fellow had killed his daughter. He had 4 prior DUIs, and his blood alcohol content was 3 times the legal limit. He got a 22-year sentence. At that time, it was at 30%. He was denied parole twice, and on the 3rd time up, he actually was granted parole. One would assume if at 12 years he was granted parole, then he would have 10 years on parole. Unfortunately, that is not the case. He has 3 years on parole, only 3 years. So his 22-year sentence basically was reduced to 15 administratively through good time. I'm fine if somebody gets good time credit, if they truly earn it toward their release eligibility, but their sentence is what the elected judge actually sentenced them to. So that's all this bill does. It just says in a situation like I just described, instead of 3 years parole, that person would have 10 years of parole. Thank you, Mr. Chairman. I stand ready for questions.
Any questions for the sponsor? All right, we're voting on House Bill 2188. All those in favor say aye.
Aye.
All opposed, no. Ayes have it. Moves on to finance.
Thank you, Mr. Chairman, members of the committee.
That brings us to item number 7. We have a motion and a second on House Bill 1858 by Representative Davis. You are recognized.
Thank you, Mr. Chair. Thank you, committee. This bill is from the Secretary of State's office, and it makes some updates to the Safe at Home program that was enacted in 2019. The bill amends language in the statute to alleviate some of the burdens on victims and their children entering the program or wishing to renew their status in the program. First, it allows participants to enter the program using an address that they are currently residing in if it's never been disclosed on a legal document. And that helps a victim that has a current address that no one is aware of, so that victim who has escaped an abusive relationship and had gotten a new address prior to registering, they can use that address. The bill also allows participants to renew their status in the program directly with the Secretary of State's office rather than having to go through reapplication through a local application assistant. Additionally, the bill protects the children of participants who turn 18 during the parents' time in the program so that they can apply to remain on their parents' renewal. And this bill helps to ensure victims and their families who count on Safe at Home program for safety can easily navigate the process of entering the program and remaining in it. And with that, Mr. Chairman, I stand ready for any questions.
All right, questions for the sponsor? Seeing none, we're voting on House Bill 1858. All those in favor say aye. All opposed, no. Ayes have it. Moves on to calendar and rules. That brings us to item number 8, which is House Bill 1719. There's a motion and a second. And Vice Chair Gillespie, you're recognized. Oh, there's an amendment on the bill too. You want to put that on there now or explain it first?
Put that on the bill now, please. It rewrites the bill.
All right. Let me get the right number here. I'm showing 013684.
Yes, sir. That's correct.
Okay, that's what we're voting on. 013684. All those in favor say aye. All opposed, no. Amendments on the bill, please explain it with the amendment.
Thank you, Mr. Chair and committee. So what this is one of many solutions to our public safety problem that we have here in Tennessee, but also specifically in Memphis. In the last couple of years, we've had a continuing revolving door into our criminal justice system. And you can place blame on many people and many entities and many crimes, but this is one solution that I think will make a big difference. And what we're doing here is we are simply removing the defendant's ability to pay while still being able to condition their overall financial condition when the judicial commissioner is determining what that bail amount is. With that, I welcome any questions that you have, and I renew my motion.
Questions for the sponsor? Representative Hardaway.
Move me after Rep. Johnson, please,
Representative Johnson.
but not after Lambert.
There is no after Lambert. Representative Johnson.
Okay, I just really want to understand. I know that we've talked about this, and I know that the concern is what we're seeing is from where is it? Because I like to look at people and talk to. There you are. People being released on their own recognizance and that sort of thing is what we talked about. I think that's a big issue. And so I guess my question is, this bill doesn't really address that. It only addresses if bail is set. And so is it really going to fix the problem that you're wanting to fix?
Go ahead.
Thank you, Mr. Chair, and thank you for that question. As I stated in my opening statement, this is just one of my solutions that I'm bringing, and you're lucky that you're on the committee that a lot of these other bills will be also addressing. So this is just one component to my public safety blueprint. And so you are correct. This will not fix the issue altogether, but this coupled with several other pieces of legislation, that is what I'm trying to do. And I will also say that defendants being released on ROR is only part of the issue.
All right. I'm hearing concerns from county officials about the cost of this to them. They fear that it is really going to fill up their jails. I've heard it from attorneys. I've heard it from law enforcement. So I know that may not be a concern to you, and I get that. But I worry about the availability of space, and that is their concern, that availability of space. So is that a concern of yours at all with this legislation?
Go ahead.
Thank you, Mr. Chair. My county and other counties have not addressed that to me. So that I understand what you're saying, but that has not been brought to my attention.
Okay, another quick one. Language seems a little bit vague. What is the difference between financial condition versus the ability to pay?
Good.
Thank you, Mr. Chair. So in the current TCA, there is a long list. 8 or 9, I guess, questions that are asked or considered. One of them is the length of their residence in their community. Another one is their employment status and history. Another one is their family ties. Another one is their reputation. Another one is prior criminal record. You get where I'm going with this. So there are several other items that can be used to gather what your financial condition is. And we're leaving that in there. This does not change that in any way whatsoever.
I feel that when you remove, I think this is too critical a piece to remove, and I do think it might have constitutional issues. So I appreciate what you're trying to do. I just don't see that this gets us there. Thank you.
Any reply? I did have a question as well. We passed Leader Lambert's bill that says public safety to be the first consideration on this list. With that, with what you're trying to fix, do you think that makes your bill kind of moot? If his bill is already passed and becomes the top priority? Go ahead.
Thank you, Mr. Chair. No, I mean, I voted for the leader's bill and support it, and I think it's a step in the right direction. Like I said before, I think that this issue is so complex, and unfortunately, what's happening in my city and my community, we need every single tool at our disposal to address it. And so, while moving the public safety, the type of crime they committed, whether or not they're a menace to public safety, is very important. There are unfortunately people back at home in these positions that are making still the bulk of their decisions based off the financial ability to pay. And so that's why I think this is still very much important and just one of many solutions.
Thank you. I've had people ask me, and I don't know what your reply is. Tennessee Constitution says people have a right to a bail. And the example used to me was somebody who makes $100,000 a year and somebody who makes $50 a week or unemployed, and they're charged with the very same offense at the same time. One of them has no problem, makes bond and goes. The other guy can't go. Which brings up the issue of, if you remove this, how does that play out in trying to find an equity in the system that is fair? And my own personal opinion, I thought that the monetary value assigned to the bond should be equal, but I've been told the Constitution that's not correct. So anyway, what is your answer to that?
Thank you, Mr. Chair. I would simply just say that while there's still a whole list of items that the judicial commissioner can look at and determine the same questions that you're kind of asking right now. We're not removing their ability to look at your employment history. We're not looking at your length of residence in the community. We're not changing any of that. And I think, and a judicial commissioner can use this information still to make an informed decision that would treat people that different financial means. So I'm not concerned about that, I guess. Is my answer.
All right, Representative Hardaway.
Thank you, Chairman. And to the sponsor, just a reminder, we're from the same community, Memphis and Shelby County. And I would also remind the rest of my colleagues that we're not the only ones that have crime. And so this applies to those folks in your community too. It's general law. But I will say that there's such a thing that's still in the Constitution called due process. There's an equal protection clause in the Constitution. And I just don't understand from your explanation, maybe you can offer something that can give me solace on how this isn't constitutionally suspect. I don't get the distinction between the evaluation of your financial condition and your ability to pay. Why would we evaluate your financial condition if we're not determining your ability to pay to the sponsor.
Go ahead.
Thank you, Mr. Chair. So yes, we do both live in Memphis, and I would say, as a response to your first question is, I cannot go anywhere in my community without being stopped by terrorized citizens. People are scared to death where I live. And if that's not the case where you live, I don't know how to answer that question, but I cannot go anywhere without this issue being brought up every single day, period. And this is my attempt to make our community safer. And to your second question, I will be honest. I mean, we can defer to legal. I'm not a constitutional scholar. I do not practice law. So if you would like to address that question to legal, I welcome that.
Well, I thought we were going to have a gentleman's discussion on this, but I not only speak to my constituents about crime every day, but I go to funerals. I'm not going to ask you how many you go to. I go to funerals where children have been killed, where grandmothers have been killed. I had a 93-year-old woman in Glenview that was killed. I had a family with the mother, grandmother, the children were in the car, no men, just women and children. And the car was shot up. And one of the ladies was killed, the grandmother. So please don't try to position this like I don't know about the crime in my community, that I don't have empathy, not just sympathy, but empathy. I have family members who have been victims of crime, from carjackings to simple burglary. So I don't need a lecture about what crime is like in Memphis and Shelby County. I don't live in the suburbs. I don't live in East Tennessee or Middle Tennessee. I live where the problem is. And I'll say again that the problem is best addressed by the folks who live there. Well, getting back to the Constitution and the protections in the Constitution, I would suggest that if, Mr. Chairman, if the sponsor is uncomfortable in addressing equal protection and the excessive bail issues, that yes, let's go out of session and I can ask those questions of legal counsel.
All right, we're out of session, legal.
Michelle Fogarty, Legal Services. Based on my review of case law, it appears that if, for instance, a person is claiming that they individually are treated different, that their own bail conditions are too onerous, that is an Eighth Amendment excessive bail claim. If it is a claim that the state is treating indigent and non-indigent persons categorically different, that would be analyzed under the Equal Protection Clause. At least where wealth is involved, court cases seem to indicate that the Equal Protection Clause does not require absolute equality or precisely equal advantages. There is a line of cases that indicate that between mere diminishment of some benefit and total deprivation based solely on wealth, there's a line drawn there. Wealth-based sanctions are impermissible when they are not merely disproportionate in impact, but rather they are wholly contingent on one's ability to pay. All of that is to say that the court would analyze this on a factual, based on the facts and based on the specific law that's being challenged. I can't give you a universal answer. It would depend on how it's challenged. For example, in Walker versus City of Calhoun, there was a bail schedule that was upheld as constitutional because it allowed for a hearing within 48 hours if the person was denied bail. The bail schedule was based on if the challenge was that they couldn't pay the bail schedule, they had 48 hours within which they could have a hearing. So the court did uphold that incident of a bail schedule. There's also a Supreme Court case, a United States Supreme Court case that found a violation of the Fourth Amendment for imprisoning a felony level probationer because he was unable to pay fines and restitutions. The court found that imprisonment for failure to pay the fine violated due process. That was for a probationer. So all of that to say, I can't give you an overall answer, but I can just give you a sampling of what some of the court cases say.
Representative Hardaway.
Thank you, Chairman. I think those facts as presented speak to, once again, equal protection and due process and excessive bail issues that make this bill not just constitutionally suspect, but unconstitutional. And I'll leave it at that. Thank you, Mr. Chairman. Thank you, legal.
Any other questions for legal? We're back in session. Leader Lambert.
Move previous question.
Previous question's been called for. We are voting on House Bill 1719. All those in favor say aye. Aye. All opposed, no. The ayes have it. Moves on to calendar and rules. Brings us to item number 9, which is House Bill 2692 by Chairman Doggett. And you have a motion and a second, and we got an amendment. Do you want that on here now?
Yes, sir, I do. Amendment Code 13874, I believe, Mr. Chairman.
Wait, that's not what I have. Hold on one second.
What's today, the 20th? Yes, that's the amendment I need.
Yeah, that's right. It's 13874.
Okay, I found that one. All right. There's a motion and a second on amendment 013874. We're voting. All those in favor say aye. Aye. All opposed, no. Ayes have it. Amendments on the bill. Please explain.
Thank you, Mr. Chairman. And I will say, members of the committee, I do have a guest here that's going to offer some testimony today. But members, this is, Mr. Chairman, this is a really good bill. And we named it after Debbie Cisco and Marie Varsos. This is the Debbie and Marie Domestic Violence Protection Act. We're seeking to offer some additional remedies to those victims of aggravated domestic violence. And I think we've got something really good right here that's going to help save lives. So, Mr. Chairman, I'll be more than happy to discuss this further, but if you would like, members of the committee are okay with, we can go out of session to hear from our guest, and then we can continue.
Is this Mr. Yon?
Mr. Yon, yes, sir.
Mr. Yon,
Alex
okay.
Yon.
We'll go out of session. Mr. Yon, if you'll come forward, please make sure the little red light's on your microphone, and please state your name for the record. And you have 3 minutes, and then we'll ask questions.
Thank you. Hello, my name is Alex Shawn, and I was born and raised here in Tennessee. Thank you all for allowing me the opportunity to speak today about my mother and sister. In April 2021, my mother, Debbie Cisco, and my sister, Marie Varso, were murdered by my brother-in-law. In the weeks prior, my sister was strangulated by my brother-in-law to the point where she eventually lost consciousness. When she awoke, she was held captive with a gun to her head, pleading for her life to be saved. Eventually, she was able to escape. Over the following 5 weeks, until their homicide, my sister, my mother, myself, and the rest of our family did everything we could to navigate the very bureaucratic process domestic violence victims face every day in Tennessee. We lived in a constant state of fear, not knowing where my brother-in-law was or what harm he could do to my sister or our family. While several things could have been done to make it harder for my brother-in-law to harm our family, there is only one thing that I've been able to identify that if implemented at the time of their death, they might still be with us here today. And that's GPS monitoring with victim and law enforcement notification for domestic violence offenders. On the morning of my mother and sister's murder, my brother-in-law waited outside my mother's home for 45 minutes. In his rental car, he had duct tape, gasoline, battery acid, zip ties, and a taser gun in addition to his firearms. He had intended to kidnap and torture my sister.
He stalked my sister and our family for weeks, leading up to this moment to understand our schedules and looked for the precise time to attack. As my sister walked out the front door that morning to get into her car on the way to work, she saw him from the corner of her eye. Thinking quickly, she put her belongings in the car to act normally and then walked back inside, locking the front door. As she locked the door, she ran upstairs to secure her firearm while yelling to my mother, who was in the kitchen getting ready for her day. The two braced for his attack, but were eventually forced to run outside, where he proceeded to hunt them down between houses that were no more than feet apart from each other. While my sister was successful at delivering 3 bullets into my brother-in-law that morning, she was simply overpowered and outgunned. I often wonder how things would have gone differently. How things would have gone differently if she knew that he was sitting outside waiting for them. They could have contacted law enforcement, secured their firearms faster, strategized a plan, and even had time to say goodbye. You all have the power and ability to ensure that others don't experience what my family has endured. I want to thank Chairman Doggett, the other bill co-sponsors, and I also want to thank Leader Lambert for continuing this important conversation. Thank you all for your time here today.
Sir, I am so sorry for what you have been through. I am so sorry. Questions for this gentleman? Leader Lambert.
Been a long journey, brother. I know we've first started talking, it wasn't but a few months after this happened, and just thanks for keeping coming back, man. I mean, it's just, it's horrible. I don't know how you have the strength to come down here all the time, and I know you and Chairman Doggett have worked really hard on this bill. But I just appreciate you coming down and sharing what your family's gone through, because it matters. And you know that. You and I've talked about that before. But man, just to be able to stand at that podium and just be able to articulate, I couldn't do it. I don't think any of us could. And so it's just, you're stronger than you can imagine. And I know your sister and your mom are proud of you. And so it's just, thanks for being here today. It's a long trip for you. And this has been a long journey. So I hope everybody supports this bill today. I know my friend from Shelby County has been pushing for something like this for years as well. And so just thanks for being here today.
Thank you.
Representative Towns.
Like, it can't be said any better than it's already been said now. It's like a nightmare, you know. But even in adversity, in the midst of adversity, somebody has to stand strong as you are doing to try to change it for the future. We appreciate you. We pray to God cover you and the rest of your family, strength and prayer to keep going, to deal with it. It's just, it shows you as human beings how evil we can be. You know, it's just a terrible thing. I hate to ask you this, but I want to know what happened to the guy.
That morning, he, after he shot and killed my mother and sister, he got in his car, posted a suicide note to Facebook, and then proceeded to drive to his residence, where he was later found killed.
So the shots that your sister were able to get off with didn't help his untimely demise.
According to law enforcement, they believe that he would have succumbed to the wounds.
Right.
She had delivered a shot just above his heart,
Right.
One in his stomach, and then one on his hand.
Are you the older brother or the younger brother?
The older brother, 5 years difference.
Yeoman's job is a big brother. Okay, thank you so much.
Thank you, Representative.
Representative Carringer.
I just want to say I'm so sorry that you have to be here today. And my prayers, my love for your family are with you. And I'm so sorry. And I will, because you're here today, is what is going to help us be able to change the law so that no families have to go through this. And I'm just so sorry. I'm so sorry. And I've had friends that have suffered the same type of stalking, and one whose daughter was killed as a junior in high school. And so the laws, that's what we're here for, is to protect our people here in the state of Tennessee. And I just want to thank you for coming down here. I know only God could give you the ability and grace and power to be able to stand here and tell that I'm so sorry. And we just hope that we can do something, that no other families have to go through this. So I will not only support this bill 110%, but I will also co-sponsor on it. So
I appreciate that.
thank you.
Leader Lambert.
Thank you, Mr. Chairman. Just so you know, everybody on the top row just signed onto the bill after your testimony. We'll leave it to the bottom row to decide what they want to do. But at the same time, just so you know, I mean, your words matter, man. Your testimony matters.
I
So,
appreciate that. Leader. Thank you very much.
All right. Representative Hardaway.
Thank you, Chairman, and thank you for being here, sir. You know, we've been at this a long time, and I know Judge Carter is looking down and he's nodding his head in approval that Chairman Doggett has been able to get it at least over this finish line, and that we're going to make the very best effort to get it through finance and get it passed on the floor of the House. It's an appropriate memorial to your sister, and I can't think of anything that's more consequential than making sure that it's mostly women, that women are protected from those who seek to terrorize them. And that's what it is. They seek to terrorize their victims. And it's so wrong that I couldn't have enough words to describe it. I believe that this will be one of those bills which will really be consequential in nature. There's going to be working again with Leader Lambert and Chairman Doggett. There's another bill that's going to be on the floor Thursday to make sure that the victims have the information when the incident occurs, so they can pursue this issue if the courts don't notify them or give them the information on the process, the procedure. That bill will require that at the time of the incident that the officer responding will make that information available. So it gets to that gap between the law being available and the victim knowing what you're describing, unfortunately, has happened too many times over the years. And the victim is not merely, as in your case, the victim that has the relationship, but research, and you'll find that law enforcement officers are murdered merely because they're responding to a domestic violence situation and they don't know where these nuts are. If they know that they're there and willing and really wanting to waylay them and ambush them, then they would be prepared going in to assist the victims who called them in the first place. And you probably are aware that we just had nationally, there's a story of 2 law enforcement officers and a EMT that were murdered responding to a domestic violence situation. So the work that you're doing, there's a proven need for it, and I compliment the fact that you're able to, your demeanor suggests that you're feeling it, but you're still able to effectively communicate with me and my colleagues. And I think the fact that, as Leader Lambert said, that everybody is signing on now speaks volumes for your effectiveness. Thank you for being here, sir.
Thank you very
And
much,
my
Mr. Ward.
condolences and sympathies.
Thank you.
Okay. Any other comments? Sir, thank you again so much.
Thank you all very much. I really appreciate
God bless you. We're back in session. Chairman, Representative Towns.
Mr. Chairman, thank you. Got a question for Leader Doggett, Chairman Doggett. Look, Chairman, if you don't mind, would you explain something to me? In the event this bill becomes law or passes the committee, explain the scenario. The person receives a notification, or how does it work? Explain exactly how does it work, and also include in there, what if the guy, just explain how it works, and then I have a second question for you.
Chairman Doggett.
Thank you, Mr. Chairman. Thank you for the question. I do want to say this, Alex, I've been up here 6 years. I've never had a bill where the whole committee signed on to it before I even told them what was in the bill. And there's signatures on this sheet that I've never seen attached to a
That's
bill
true.
that I'm carrying. So
That's true.
it's pretty awesome. No, thank you, Representative, for the question.
Yes, sir.
And so let me go over a little bit about what this bill is actually doing, and then I can dive a little deeper into your question. So with any time with domestic assault, domestic violence is, speaking from a former law enforcement officer, is oftentimes one of the most dangerous calls that you can go to. And unfortunately, sometimes it is deadly.
Yeah.
And for our domestic violence victims, we have done what I think has been a pretty good job, really a good job in the past of providing remedies to our victims. For them, we've put in place several years ago the 12-hour hold for those victims that the offender is being held for 12 hours. That gives a victim an opportunity to make arrangements if they need to, if they share the same home or in the same vicinity, that they could leave. Last year, I believe it was, we had brought the 24-hour hold that a magistrate or judicial commissioner could place on the offender if it was an aggravated strangulation was involved in it. The most crucial time for those victims is between the time that the incident or the offense occurs and then the time that they go to court. And like the story that Alex shared, these victims so oftentimes are being hunted like prey by their offender. And so what we are seeking to do with this bill is that we are requiring that, one, aggravated domestic assault, that this GPS system has to be utilized. Two, it has to be worn by the offender. And the reason for that is if that offender comes into the area, and those areas, those zones will be set by the court, by the magistrate. But if that offender comes into that area where that victim is, they're going to get immediate notification, real-time notification, so they know exactly when that offender comes into their area. That's going to give them time. Time is our most precious asset that we have, especially if you're a victim, to have that time to say, I've got to leave. I've got to take precautions or steps to help ensure my safety. They can notify 911. They can have law enforcement respond. If that offender cuts off that monitoring system, the monitoring system, the one that's actually conducting the monitoring, they're going to know that, okay? They're going to have written policies and procedures that are in place, these protocols with the locals, with the county or the city, or with their 911 systems, whatever they choose in each community to set up, but they're going to have that in place. So law enforcement will be notified. That victim is going to be notified as well that they've shut off their device. And so that's going to raise their alerts. That's going to give them an opportunity to find whatever means necessary to take shelter and refuge during that time.
Go ahead. Thank you, Mr. Chairman. Thank you for that explanation. The system itself, does it alert you when the person within, the perpetrator is within a mile or half a mile? What's the range on it?
Well, the range will be set by the courts, okay? Give an example, if someone lives here in Davidson County and they live right out here close to the Interstate 24 or 40, and that offender works downtown.
Okay.
They can set that to where when they drive by on the interstate that it does not necessarily alert them. They can also set it to where it does alert the offender so that they know. But they can tailor that zone to fit, to stay away from where the offender works, resides, or where the victim works or resides, any places they might go. Our current domestic violence laws that we have in place will not change. And so there's always certain conditions that have to be met that are placed on the offender when they're granted bail or when they're released, pre-trial. So they'll have those conditions remain in place, but this is an additional tool that's going to help alert them to when danger is near.
There again, that's the reason I signed on the bill. I appreciate the explanation. Hopefully it's going to be a formidable tool to help us, as my colleagues from Shelby County stated, save a lot of our women and girls in this community from this weakness that some of these heathens display when they are trying to retaliate against them, So thank you for it. Okay.
Any other questions for the sponsor? All right, seeing none, we're voting on House Bill 2692. All those in favor say aye. Aye. All opposed, no. Ayes have it. Moves to Finance, Ways and Means. Thank you.
Yes, sir. Thank you all.
Any other business for the committee? We are adjourned.